Good morning and welcome to the Public Service Commission of South Carolina. We are here today for a special commission business meeting. We have a very limited agenda today. Before we begin, let's take a roll call of commissioners. With us virtually, we have Commissioner Irvin. Present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, and Chair Belser. Before we begin, will you join me for a moment of silent reflection? Thank you. Mr. Scarborough, good morning.
Good morning. Thank you, Madam Chair, and good morning, Vice Chair Powers and Commissioners. First order of business is to set the date of the next commission business meeting. Staff recommends that the next regularly scheduled meeting be held on Thursday, December 1st at 2 p.m.
Thank you, Mr. Scarborough. That's our regularly scheduled business meeting, and it will be scheduled for Thursday, December 1st at 2 p.m. Today
we have just two items on the agenda. Item number one is in docket number 2022-142WS, which is Defusky Island Utility Company Incorporated's motion for the confidential treatment of late filed rebuttal exhibit GCW-3 and the final disposition of the utilities application to adjust its rate schedules and increase rates.
Commissioners, we've heard agenda item 1 as described by Mr. Scarborough. Is there a motion?
Madam Chair, I'd like to make a motion.
Commissioner Carol Lee Williams.
Thank you. Madam Chair, Vice Chair Powers, and fellow commissioners, I'm going to be making this motion in two parts. So the first part is, in this docket, there is a pending motion to strike raised by the Office of Regulatory Staff regarding certain evidence and testimony presented by Defusky Island Utility Company. I move that we deny the motion to strike and utilize the Commission's professional and judicial discretion to weigh the evidence presented. Additionally, there is a motion for confidential treatment related to information contained in the late filed Exhibit 20, submitted on November 9th, 2022 by Defusky Island Utility Company, also known as DIUC. I move that the Commission grant this motion for confidential treatment. Further, I move that the Commission adopt the following. Item 1, the approved ROE for DIUC shall be 9.07%, and the approved debt rate for DIUC shall be 6.81%. Item 2, the capital structure as proposed by ORS shall be approved at 48.01% debt and 51.99% equity. I so move.
Commissioners, we've heard the motion from Commissioner Carol Lee Williams. The first part of her motion, she's indicated there'll be a second part. Is there any discussion? Hearing none, we'll proceed to a roll call vote, beginning with Commissioner Carol Lee Williams.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Irvin, we can barely hear you.
Aye.
Okay, you may want to boost that as we go forward. Commissioner Thomas.
Aye.
Commissioner Justin Williams, I believe you're recused on this docket. Is that correct?
Partially, Madam Chair. I'm not voting because I did not attend all of the hearing, and due to the 15-minute rule, I'm not voting. I'm not recused in terms of having a conflict, but I didn't attend the entire hearing, so I'm not voting. Thank you.
Voting.
Mm-hmm.
Vice Chair Powers.
Aye.
Commissioner Carol Lee Williams, I appreciate and certainly understand your motion. I just have a slightly different view, and therefore I am voting no. I have a different view on the capital structure. I agree with the rest of it, but because it's a composite motion, I'm respectfully voting no. However, is that everybody? Yes. The ayes have it, and the motion carries. Commissioner Williams, you're recognized for the second part of your motion.
Thank you, Madam Chair. The Commission rejects any inflation or customary growth factors for power cost, chemicals, supplies, and maintenance cost or transportation cost. ORS's calculation of bad debt expense resulting in an adjustment of negative $26,579 is accepted. Accept DIUC's gross plant and service adjustment, which includes the company's Melrose, Bloody Point service area, net of certain additional removed invoices removed by ORS for a total adjustment of negative $18,184. Accept DIUC's accumulated depreciation adjustment reflected in witness White's rebuttal testimony for a total adjustment of negative $252,909. Accept DIUC's depreciation expense of CIAC amortization, net of CIAC's amortization. Thank you. Accept ORS's adjustment of $424,858 for amortization of rate case expenses incurred through the date of the hearing and for deferred property taxes. Accept ORS's calculation of cash working capital, which acknowledges the removal of bad debt expense. Accept total unamortized rate case expenses of $1,618,227 to be amortized over 3 years. Rate case expenses related to the company's pending appeal to the South Carolina Supreme Court are deferred until conclusion of the appeal. Accept ORS's adjustment of negative $1,483,052 to unamortized balances accounts, reflecting that unamortized rate case expenses should not earn a return in rate base. Accept ORS's recommendation to use the current gross receipts factor. All other adjustments agreed to between DIUC and ORS are accepted. DIUC shall be required to use a certified public accountant to calculate its accumulated deferred income taxes and excess deferred income taxes before its next rate case. DIUC shall be required to establish a regulatory liability as required by Order Number 2018-308 and to refund excess federal corporate income tax collections due to the Tax Cuts and Jobs Act to customers over a 5-year period or until the balance of the regulatory liability reaches zero via a decrement rider. DIUC shall conduct a depreciation study before the company's next rate case. This study shall be put out for bid. With the most economical, professionally competent bidder selected, Guastella and Associates is also permitted to participate in the bidding process. DIUC must provide access to annual consumer confidence reports to its customers. We request ORS to provide updated accounting schedules and schedule of rates consistent with this motion by December 2nd, 2022. In the same format contained in the ORS proposed order, such schedules shall be circulated to all parties for review and comment within 7 days of receipt of ORS's filing. To the extent that ORS needs further information from the company or any other party to develop these schedules, the parties are hereby instructed to provide such information within 3 days of the request. And I left out one. DIUC shall conduct a cost of service study before the company's next rate case. Guastella Associates is permitted to conduct the cost of services study. I also move that the Commission notes that there will be an upcoming review of DIUC's management agreement relative to DIUC's role in the provision of safe, reliable, and economic customer service. I so move.
Thank you, Commissioner Williams. Commissioners, we've heard the motion from Commissioner Carolee Williams. Is there any discussion? Commissioner Williams, I have two clarifying questions, if I might. I believe in the beginning of your motion, you stated that the commission rejects any inflation factors, and I think you said customary growth, and I think you meant customer growth. Is that correct? I may have just heard wrong or processed it wrong, but instead of customary growth, I think it should be customer growth.
Customer growth, absolutely.
Okay.
Yes.
And with regard to the part dealing with DIUC's gross plan and service adjustment, I think you referenced the Melrose and Bloody Point service area. There was also some discussion of Hague Point. Does that include that? So, and I reckon my question is, does your motion recommend the per book, or what was on the books for the gross plant and service at the time? What was on the books at the time that DIUC took over from the company in bankruptcy?
That is the intention.
Okay, I just think that there's a portion that came up during the hearing where ORS proposed an adjustment because I believe it was Mr. Costella's exhibit did not reference Hague Point, and so ORS made an adjustment. So we're not accepting that adjustment. Is that correct?
Correct.
By your motion?
Right.
Okay. Thank you for the clarification.
Madam Chair,
Commissioner Thomas.
thank you. Again, just a little clarification. The DIUC was mentioned throughout the motion, and I believe that is the correct abbreviation for the company. It seems to me that I might have heard in the last part of the motion that instead of DIUC, it was mentioned DICU. And just in case that's what happened, I just want to clarify that consistently throughout it should be DIUC. That's all I had. Thank you.
Commissioner Thomas, are you offering that as a friendly amendment?
Yes, ma'am.
Thank you.
I accept and appreciate the friendly amendment.
Thank you. So that if it was misstated throughout the motion, the correct, for the written motion or the directive, it should reflect DIUC. Is that correct?
Correct.
Thank you, Commissioner Williams and Commissioner Thomas. Commissioners, any further discussion? Hearing nothing, we'll proceed to a roll call vote, beginning with Commissioner Carolee Williams.
Aye.
Commissioner Caston?
Aye.
Commissioner Irvin?
Aye.
Commissioner Thomas?
Aye.
Commissioner Justin Williams not voting. Vice Chair Powers?
I vote aye.
The chair votes aye. The motion carries.
Item number 2 is in docket number 2022-256E. This involves the public interview related to the proposal in response to solicitation number 54000-24077 in Commission Order number 2022-593 on September 1st, 2022. This order granted permission to Commission staff to issue a request for proposal to retain independent outside consultants, including counsel and advisors, to serve as consultants to the Commission in this docket.
Thank you, Mr. Scarborough. And with regard to item 2, we are fortunate today to have representatives from Sabre Partners who filed a response to the request for proposal. And in particular, we have Mr. Joseph Fitzgerald, who is on the Commission's right, and Mr. Paul Sutherland. And gentlemen, welcome. Thank you for being here today to explain your proposal. And with that, I think y'all have a presentation for us and would invite y'all to begin at your leisure.
Yes, thank you very much. My name is Joseph Fitzgerald. I'm the Chief Executive Officer of Sabre Partners, LLC, located in New York, New York. And to my right is Paul Sutherland, who's a Senior Advisor. And we the presentation we have today, I think you have a printed version. Printed version in which we reorganize some slides and such, so it's not going to match completely. But let me begin. The key, we submitted a detailed answers to your questions, which were very good questions and clearly in terms of trying to understand what securitization. We think that, you know, these are things looking about Sabre Partners' origins, our expertise, utility expense, litigation process, and a proposed work and timetable plan. Sabre has been around for about 20 years, and we say we've been tested and trusted in this area for that period of time. Our core principles are pretty straightforward. We're an independent organization that focuses on having an integrity in terms of our actions. We look for innovation, new ideas. We question that's the way it's always been done before, and nobody will notice, to find quality and value in providing assistance to our clients we serve as trusted advisors. We were established in 2000, and this was the announcement that was sent out then. The initial principles were myself, William Moore, Kevin Stacy, and Paul Sutherland. I was a former investment banker, managing director at Prudential Securities and Bear Stearns. Bill Moore was the chief financial officer at Western Resources. Kevin Stacy was a major partner in a Thielen, Reed & Priest, which was a utility law firm. And Paul was formerly with the FPL Group, Florida Power and Light. Mr. Moore left Sabre's to become, Mr. Stacy unfortunately died from Agent Orange, from his service in Vietnam. Mr. Moore was enticed back to Western Resources to be its CEO and has since retired. And we've had new folks. Basically, at that time, we were looking at a deregulation of the power and electric utility industry, and we thought that there was a specific opportunity for a group like ourselves with unique business and financial expertise in the energy and utility industry and finance and legal to assist in that area. At that same time, we began providing financial advisory services related to commissions on securitization. And over the period of 20 years, we have worked in multiple states for multiple commissions for approximately $13 billion in terms of transactions. All of our partners and folks who are today are really senior, and we provide senior advice, senior level, which it would be curated specifically for South Carolina. We are a close-knit team. I mean, we have all worked together for over 20 years and even probably 10 to 15 years before that. Part of the way we came together was because we had worked in our various previous capacities together. I as banker, others as utility executive, as well as finance executives. And over that period of time, we've developed a very in-depth expertise and experience that will be able to answer all your questions. And over this 20-year period, we completed a lot of assignments in this area. 17 transactions, $13 billion, 9 utilities, more than 28 underwriters. Our goal for South Carolina will be what we were able to achieve in Florida in 2016, and a meeting of the commission at the end of that transaction this is what occurred.
Okay, good morning, and thank you for joining us here today. Meeting is called to order for the petition for issuance of the Nuclear Asset Recovery Financing Order by Duke Energy.
So this was a very successful effort. A lot of people were involved, and we would have not had this result, though, without the tireless efforts of our financial consultants, Sabre Partners, and Joe Fischera in particular. On the first slide, we talk about the total financing cost of 2.72%. This is the lowest cost in the history of investor-owned utility rate reduction bonds. The investors that bought these bonds, did so at interest rates that were in line with U.S. agency securities such as Tennessee Valley Authority, Fannie Mae, Federal Home Loan Board, and some of the largest, highest rated global corporations such as Johnson & Johnson and Exxon. The next slide, we wanted to highlight the 18-year maturity specifically because when you look at this, this is a comparison of how the DEF project finance bonds priced relative to comparable issues of these other names I mentioned, priced right on top of Tennessee Valley Authority. Tennessee Valley Authority sells billions of debt. They're a well-known issuer. DEF project finance didn't exist more than 6 months ago. So this was almost akin to an initial public offering. We were able to do so with the collaborative effort of Duke Energy Florida, Sabre Partners staff, and the other outside councils that came together to make this successful. But this is a strong signal that those efforts were successful.
This fantastic outcome is no accident. As you pointed out, it is the culmination of months of hard work.
We owe a special thanks to your staff on the bond team led by Andrew Mallory and including Mark Cicchetti and Roseanne Gervasi. They were vigorous and very knowledgeable advocates for the customer's interests and obviously had the full support of the executive director and the general counsel in their advocacy, and we deeply appreciate it. But the OPC saved its best thanks for the Commission's advisor, Sabre Partners, and especially Joe Fischera, and the Commission's bond counsel, Dean Criddle, who brought impressive expertise, experience, and discipline to the transaction, and without question were instrumental in saving many millions of dollars for the customers in current and future costs. Through their dogged and expert advocacy to achieve the optimum and lowest cost for customers at the outset.
We support Duke's issuance advice letter. We support Sabre's opinion letter. We are profoundly grateful for the $684 million of additional savings over and above what you already approved in the 2013 global settlement. And I'm profoundly impressed. The Federation is profoundly impressed with and by all the work that went into this, and even more so by the result. This is just really, really great. I'm going to close with 3 words: wow and thank you.
That's great. But I also would like to acknowledge the foresight of those who worked on the legislation in providing the resources and the direction for the Commission to be able to hire outside bond counsel and outside financial advisor. I do believe that was a very important part of the process and an important part of the success of the result, working closely, of course, with our staff and all of the involved parties. This is truly a good news story, and I hope that that good news gets out that although it is a complex financial transaction, it is an innovative financing mechanism to address a very unique situation. And I do believe that the result that we have before us is consistent with the statutory objectives, that the lowest charges consistent with the prevailing market conditions have been achieved, and that we were also able to achieve the greatest possible consumer protections. Lots of movies. And we get positive results. Positive results. So seeing that we do not need to have a motion, and we don't need any further discussion, if no one has any further discussion, a big thank you again in closing, and this meeting is adjourned.
That's our objective, hopefully, for this meeting. I think in terms of both your legislation, in terms of the process going, we'd like to have that same type of meeting in this room at the end of this transaction and for the future uses of securitization. It is a possible effort. And what I'd like to do right now is just go a little bit about background about the securitization product, ratepayer-backed bonds, and give you in terms of the market that you're entering now, which is a little bit different from what Florida was entering in. There have been really 8 basic uses of securitization, and Sabre Partners has been involved in, I think, 5 out of those, from just facilitating rate reductions to recovering stranded costs, buy downs of market purchase agreements, deferred balances, costs of new pollution control, storm recovery, distributed generation, and coal and nuclear plant retirements. And what you can see here in terms of this slide, this has been around since 1997, and there was a lot of issuances in the in 2000 to 2010, and that orange line is the amount of bonds that are outstanding. The bottom bars are the amount that was issued each year, and as you can see, the amount was outstanding was declining over time until just in the past 2 years, and now exploded almost back to where it was 20 years ago in 2001. Now that's both a good news story and a challenge story. As we said, in terms of the uses of stranded costs of these types of bonds, storm recovery, which has been authorized by the legislature here, is the second largest and is growing as a result of climate change and other natural disasters, and particularly with the weatherization Uri event last year. Securitization was used to help mitigate rate impacts and provide savings to customers. But it isn't all that consistent with a plain vanilla approach. When you look at the number of utilities that have issued a lot, you'll see that that biggest bar there is Pacific Gas and Electric Company in California, who's issued over $13 billion over this 20 years, a lot for wildfire damage, bankruptcy, reorganization, as well as for the initial rate reductions for a deregulated market. Duke Energy has 3 transactions, those gold bars up there, where they did 2 transactions in North Carolina and 1 in Florida. The initial transaction and petition that you have before you is a small transaction, but and there have been a number of these transactions of $350 million and less. The yellow ones are ones that Sabre Partners advised on. So we did transactions as small as $21 million, and I think the largest is $5 billion, I think, just recently done. But within the range of what this initial petition, this is right within what has been done and things that we have worked on as well. So one might think that given over this 20-year period and such, we might think this is a boilerplate project, but it really isn't, because there is no real standard approach. There is no real cookie cutter that we can simply apply to South Carolina and expect the same results. There have been documentation change, there's differences in terms of market turnover, and this flood of issuance in the past 2 years does create specific challenges. In your written request questions, just there was a lot about process questions, time, transaction timing. Let me try to go through those quickly. Many may ask, how long does it take once the commission makes a decision? This is a scatter plot, which might drive some people nuts, but it shows you the actual number of days from a time a commission made a financing order decision and the bonds were actually sold, the date of a prospectus. As you can see, it's a very wide range from some within 90 days and some as long as 600 days that you have to resolve appeals. There are rating agency concerns, there's SEC, additional litigation. And then when going forward in these transactions, we might think about savings just in terms of the absolute interest rate, but much of that absolute interest rate is not in your control because it's dependent upon the Fed determining where the general U.S. Treasury rates are going. So where we have to focus on is the spread, the difference between this bond, a U.S. Treasury bond, and this bond. And a AAA bond, as you see the dotted line, should be closer to the U.S. Treasury curve than a BBB bond, which is a weaker rated bond. And these bonds are supposed to be AAA and should get closer to that Treasury level. And given the fact that we're going for a AAA rating, there are only really two other AAA issuers in this country, and you've seen the ratings migration back from 2000. There were 15 U.S. companies that were rated AAA. Today, there are two, Microsoft and Johnson & Johnson. TVA has the rating of the United States, which has still been downgraded by S&P to a AA+, but is considered triple. So that should be good, and we should be able to price close to where these people are pricing. But things seem to be going backwards right now in the market because as we look at what's happened in the past 2 years, and here are two indices that talking about BBB credit spreads and AAA credit spreads. And what this shows is that when the first transaction that came from Southern California Edison in February 2021 was pretty good. It was right on top of AAA in terms of corporates. But then things started to deteriorate, and you found that the spreads and interest rates on these types of bonds were being more closely aligned with weaker credits than stronger credits. And that is an issue for ratepayers. While your absolute rate may still be low the weighted average cost of capital, the fact that you're not getting the full value for that AAA and the amazing authority that this commission will give behind its financing order and foregoing all future review, you're leaving a lot of money on the table. And here's an example where we calculated the weighted average spread, that a difference above the U.S. Treasury rate for each specific transaction over, based on where other AAA corporate securities, like as was mentioned in that video in the Duke Energy Florida transaction, Tennessee Valley Authority, Johnson & Johnson, and it was pointed out there, we were pricing on top of those levels, very, very close. And that's where you see on the far left, that's where Sabre Partners in that advised transaction was on average only about 10 basis points away from those in the different tranches. And the Southern California Edison transaction that came in 2021 actually beat us, was a little tighter. But then, as you can see, it started to change until most recently, and we haven't put in the transactions in the last month, but as of August, they were still much higher than their AAA. And that affects savings. if you discount the savings at the weighted average cost of capital, you're going to see that you're going to have additional costs for missing or not getting that top quality credit spread when you negotiate with underwriters and investors. So it's almost in the PG&E transaction in July, it was almost 9% more of the total amount, principal amount that they had to pay. Then when we did the Duke Energy Florida transaction, it was only less than 1%. And Southern California Edison was less than 1/10 of 1%. So our work plan is, from a new issuer's standpoint, is to first inform the commission, provide all technical information and answer any questions, to educate the commission and the commission staff on the workings of securitization and the capital markets and the jargon that's there, and put it in plain English. We then will evaluate testimonies and proposals from the utilities, underwriters, and interveners to provide. We will then propose, based on that evaluation of what is in the docket, making specific recommendations to the commission, and then based on the evidence, the commission will make a decision, and then we will implement your decision with the utility and others that come based on the decision that you make. Now, we have a very thorough and rigorous approach to this process. We've submitted answers to your questions, and we didn't want to overload you with information. We have publications concerning the, choosing the right discount rate, methodologies for relative value, how you benchmark the securities, what you should do, looking at high-quality corporates as we discussed, and how to evaluate pricing success. All of these have been developed over time for our clients so that they can understand and make more informed decisions. Our clients make the decisions. We are just the trusted advisors, the sources of information, and providing what your objectives are, giving you alternatives, telling you the pros and cons, and allowing you to make the decision. Our work plan is a evaluation of what is out there with an open mind to requiring transparency in the process, verification of the different data, identifying best practices as you asked about, identifying alternatives, providing stress tests and alternatives, different techniques. Everything at the end is to achieve a timely, efficient transaction and pricing at the lowest cost to the customer. We need to get the utility the money as quickly as possible, but without sacrificing the costs or unduly burdening the ratepayer. Over the past 20 years, we've worked in numerous states. Our clients have made comments, and I think we defer to them in terms of your colleagues in the industry in terms of what they've had to say about how we've performed in their transactions. I think the recommendations and the information we've submitted shows very detailed analysis and recommendations about how we do work plans, how quickly we can move a transaction, how we can achieve different items, and they are the best sources in terms of telling you what we are capable of and how we can best be used. And what I'd like to be able to do now is to simply thank you for this opportunity and get to your questions right now in terms of our proposal, in terms of what you've had. Thank you.
Mr. Fitzgerald. Commissioners, questions for either Mr. Fitzgerald or Mr. Sutherland? And I believe y'all may have some team members that are virtual, is that correct?
Yes, in case,
In case you need their input. Commissioners, any further questions? Commissioner Caston, I see your light.
I think it's still morning, maybe. Good morning.
yes. We arrived in the morning at 2 a.m. So,
I was up about 2.5 hours after that, so.
all right.
Relative to questions, have you had a chance to, Duke Energy, the one I'm looking at, Duke Energy Progress, supplied some questions that would have been posted on the DMS. Have you had an opportunity to look at those?
No. We only received your questions.
Well, since I breached the subject, why don't I?
All right.
Since I breached the subject, I will,
Sure.
let me ask. Referencing the Act 227, Section 5827-1170, they note that the Commission is authorized to retain an independent outside consultant to serve as advisors and counsel to the Commission. And consultants are subject to the same ex parte restrictions as employees of the Commission. Does the RFP respondent propose to serve the role of the independent outside counsel for the Commission consultant? Does the RFP respondent propose to serve the role of independent outside consultant for the Commission?
Yes.
And if you wish, what I can do, you want me to kind of read through these things quickly,
Sure.
give you a sense of them? The reference section 5827-1110 C6A of the Act requires qualified independent third party designated by the Commission to certify that the transaction complies with certain statutory requirements and the financing order. This provision requires the independent third party to provide its certification 1 day after the issuance advice letter is filed. This role may require participation in the pre-bond issuance process to be established by the Commission in the financing orders required by Section 58-27-1110. Does the RFP respondent propose to serve the role of the qualified independent third party? Third question, or third item. Please explain whether a single entity or individual serving as both the independent outside consultant under Section 58-27-1170 and the qualified independent third party under 58-27-1110 C6A meets the statutory obligations and limitations for each. Thank you, Madam Chair. Please explain the level of independence required of each and note any statutory limitations impacting communications with the Commission. And since you have that, I don't necessarily think I need to read 4 and 5, but 4 addresses fee schedule. Please describe the RFP's respondent's proposed compensation arrangement with Commission. RFP need not provide details regarding rates. And the 5th question basically related to how does the RFP respondent view decision-making authority over the transaction considering 58-27-1170. Are there any particular safeguards the RFP respondent recommends to ensure compliance with this statutory requirement? I'll give you a minute to look over that.
Madam Chair,
Commissioner Thomas?
thank you. Given that these are relatively new, at least in terms of being put in front of the potential consultant, do you think it would be appropriate to take a short break and give them a little bit of time to consider the questions and their answers?
I think that might be a good idea. At
Well,
least let them digest this a
I-
little
this
bit.
is- I don't, these seem to be all many legally oriented questions, but written by a lawyer, which
think-
means that I should go have counsel look at many of these questions and ask. I mean, we'd like to give you a thoughtful response rather than just a gut level response, and I can do that because I want.
Let me ask you this.
We'd like to actually, in terms of if you're deciding to hire us, I think many of these things would be worked out in terms of the contract, in terms of how the process goes forward here.
With regard to the first two questions, let me just take a stab at that. Under 5827-1170, I feel sure that y'all have read that section. That's the main section that allows us to, the commission to retain independent outside consultants to serve as advisors to the commission. And I think that's mainly what your responses have addressed. There is section 5827-1110, subsection C6A, part of this Act 227, that provides for, I just lost it. Excuse me a second.
Isn't that the independent certification? Is that
Yes,
what
sir. That's the advice letter with the independent certification from the utility and a qualified independent third party designated by the commission. And the way I read these questions is, do you think that can you function in both roles, or does that need to be separate?
Historically, we've functioned in both roles. I mean, the legislation in South Carolina is very progressive, we think, in terms of incorporating many of the innovations that Sabre Partners developed almost 20 years ago, at first with the Texas Commission and then with the Florida Commission, in terms of the establishing the need for an independent opinion and certification to be provided to the commission in the process. And I could give you the actual transcript from the February 2000 meeting where this came up and was discussed first about Commissioner Brett Perlman and Pat Wood, who's one of our brought up the point of saying we had an advisor, we want to have an opinion, we want to have that similar to like an M&A fairness opinion. We want people to all, at the end of the transaction, for the commission to evaluate and make a decision. If you saw in the video, as you saw, there was references to the Sabre opinion. And some of the group said, we agree with the Sabre opinion. I think even Duke said, we agree with the Sabre opinion that was provided to the commission to make its final decision. So we don't see historically the distinction being able to be advisor to the commission and providing that opinion to the commission as part of our duties. But it seems here that the utility may be trying to make a very hyper-technical legal argument about separating those two. I don't know, and I would have to consult counsel.
Madam Chair,
Commissioner Caston?
I understand, and I was not trying to ambush you with that. I wanted to make sure that
Well, it's
you at
interesting that
least
this
seen
is
it or were aware of
November
it.
10th, and I don't know why we weren't provided with these I don't know.
Well, in any event, Madam Chair, certainly support that too, because I wouldn't want to sit there and answer this in about 5 seconds off the top of my head either, but,
Well, anything that starts out section 52-27-111, open paren C, close paren C, open paren 6, close paren 6, open paren A, you just kind of wonder. You gotta think.
well, I think the question
I used
is,
to have a lot of tax counsel. They would always bring out the tax code, and we could go right to it. But
Commissioner Caston and Madam Chair.
Commissioner Williams?
As another alternative to what Commissioner Thomas proposed, would it make sense for you all to submit your answers to this letter in writing within a certain amount of time? And that gives you the chance off camera to talk with your attorneys and put together, your thoughtful, realistic response.
Well, and I think, gentlemen, our schedule that was published in this docket asked for a final conflicts check letter by noon on Monday, the 28th, which is, a week away. Would that provide sufficient time to allow you to maybe submit some brief responses into this letter? To me, those two questions kind of go to, by advising the commission under Section 1170 and working through the documentation that you've kind of laid out and your process that you've laid out, is that going to somehow conflict you out from issuing the other letter under that, C6A, 1110 C6A?
I think I needed to take more philosophy courses when I was in school. I don't know, in terms of, I mean, I suppose one could fashion an argument that it is one could fashion an argument that it isn't. I think the essence here is many of these things should be dealt with once we're engaged and we can talk about and decide.
In the contract.
Yes.
The contract negotiation.
Right. Well, yes, and through the process, because we don't even have an application yet. And you're going to interpret the law and such, I believe. You're in a quasi-judicial fashion at making these determinations. I would imagine Duke may want to submit a brief on this. I mean, I think when we participated, for example, as the advisor to the North Carolina Utilities Commission public staff, Duke felt that was a conflict because, similar to your Office of Regulatory Services, it would be they were an intervener. You make they're opposed. They can't give an opinion. The commission accepted that argument in North Carolina, and here we're not working for the Office of Regulatory Services, which is similar to the public staff. We would be working for you. So I see, it's sort of a little bit of a, Duke is maybe making a flip argument now, because we are considered in South Carolina that now if we work for the commission, we can't provide the opinion. I don't know. But I think the substance here is that this is a new statute for you all. This is your first time doing this transaction. Our team is seasoned and experienced and been through this in multiple jurisdictions with people like yourself who have written detailed recommendations about how we've helped them understand and how they've made decisions. And that's exactly what we want to do here, is help you make the decision, give you the information, and you then can decide based on the evidence. When we get into legal arguments and such, my mother did want me to be a lawyer. I disappointed her. I'll never live that down. I never was able to explain to her what I really did for a living. When I told people, when I told her, I said, people pay me for my advice. And she said, why would they do that? You're not a lawyer. But, so I'm a finance executive, so is Paul. We have counsel available that would be part of the team that can answer and go through and brief these questions and then make a decision. I don't think this should stop us from you evaluating our proposal and hopefully entering into a contract to move forward so we can get to work and have confidential conversations with you, in accordance with the ex parte rules and such, not talking with other parts of the thing. And then when an application comes through, you'll evaluate, make a decision. And if at that time you decide we need to have an extra party and an extra cost to provide an opinion, or we have done it in the past, that will be your decision and we will abide by it. Or you may make the decision to say, no, we think we can follow the other precedents. We will abide by that, and I would have hoped that Duke would abide by that, by your decision as well. But the point is, you need to have the information, and we should be able to then make the decision. But I don't think it's a conditioned precedent to us moving forward.
Madam Chair.
Vice Chair Powers?
Thank you, Madam Chair. Based on your comment, when I was probably about 10, my grandmother wanted me to be a preacher, not a lawyer.
Yeah.
Now that I'm 70, I'll probably be a lot better off if I'd have followed her advice rather than what I did do.
My mother would agree with you. All right. God rest her soul.
Commissioner
So
Cass?
we can submit written questions if you want. But that's like, this is like, are we already in litigation? You know, it's like, what are we doing here? I think you need to get technical information and advice and perspective. And I think we're in the best position to provide that to you in our application and our writings. And I'd like to be able to answer any of those questions about that application as opposed to these legal issues.
Madam Chair,
Commissioner Caston?
if I may, I think the suggestions, Commissioner Carolee Williams and your suggestion about next Monday, if that is suitable to you gentlemen, because again, you know, the intent wasn't to broadside you. Are you aware of this? You know, the interesting questions. I think it would be worth, you know, taking some time, discussing it, and getting back. So
Wouldn't this be, Commissioner, aren't all these issues more that should be in the brief in their application and their petition after you hire? I mean, you conducted an RFP for services, we responded, and this seems to be issues that would be in a petition in case, where they might say how the process would be.
Well, and I think the RFP addressed the independent consultant under 1170. And this question goes to the certification letter, I believe that's what it's called, under, one of the questions under 1110. And as I hear your response today, as we go forward with this, we may be able to decide that, well, wait a minute, if we were to hire Sabre as our consultant, we may be able to say at some point, we think Sabre can do this and the parties can respond, or we may decide we might better get another consultant to do that letter after the fact.
In our RFP response, we proposed giving this certification because this is the certification that we have done before, and we have written and published, and we think the certifications are very important because the wording of the certification is important, and that was one of the issues that, you know, where we went in Florida and in Texas, we know what those certifications were strong. We've seen other certifications that seem to have caveats that are not unconditional certification. They say things like, assuming all this information is correct and without independent investigation, X. Well, if you make an assumption that everything is true and you don't do any independent investigation as to whether it's true or not, I guess you can make any conclusion after that. You know, in accounting, there's at least there's testing that needs to be done. In fairness opinions, there's due diligence that needs to be done. And there are various standards and such, and we've given testimony on that. I know there's some disagreement in the financial community about wanting to give tough certifications, especially underwriters who do not have a fiduciary duty to the utility or to ratepayers. And having been an underwriter, I know they're on the arm's length on the other side of the table. Asking them, as the transcript from the 2000 meeting where the commissioners discussed this, you know, they knew, but they said, look, everybody needs to sign on. We want them all at the same levels. And we would be able to share with you in executive session those forms of certifications that had been given in other jurisdictions. We'd also be able to arrange calls for you and staff with other people about those types of certifications versus other certifications. And that's some of the things that for you to make a decision. But I think almost all of these questions are like in an application that assumes something's going to happen, and then the utility is proposing X or Y, and then the commission can make a decision.
Okay.
So, I mean, the answer to your question, if you want us to answer these questions, we will, and we want to be responsive to you. But these appear very hyper-technical, legal, and could be probably tens of pages of briefs and counter that you could do.
I don't think we're looking for briefs or tens of pages, but if you can address.
No, I mean, we would answer it because I think our
briefly
simple answer is, I think we could do both of these transactions without a conflict. And the other issues, 4 and 5, I think relate to how the commission wants to provide in terms of our contract and such. And 5 is specifically, we also redirected, we know that the law says you don't direct the placement of the utilities. We never did. You know, safeguards to recommend, ensure compliance to the statutory requirement, other than saying that we will comply with the statutory requirements at all. I don't know what other safeguards we can provide.
Madam Chair.
But I'll answer, we'll submit answers to questions. And any other questions you might have, we'd like to, since we're here, would like to be able to address.
Commissioner Castanet, you were.
Just to wrap this up, at least from this, I don't want to belabor the point, but I think the discussion now was.
Are you satisfied? Do you require?
I am. I think question 1 and 2 kind of gets to question 3. I mean, can you serve both roles? So I would, yes, ma'am, I'm satisfied with what the suggestion was to just respond.
Any other commissioners want written responses?
For clarification, are you saying, Commissioner Caston, that you're satisfied with the discussion today, or would you like the written answers?
I think the prudent thing to do would be to look at these and respond in writing.
Okay.
I agree.
If that satisfies the commission, if it satisfies you gentlemen, and I agree. I don't think a brief or such is needed, but you know.
I think we'll be able to respond quickly to that, but I don't know. Yes. Now, there's consult with counsel, like I said, each of them starts with some sort of legal and interpretation, and there may be a theory behind that Duke has. Other people might have another theory. Like I said, we want to be responsive to you. We will submit answers, and we'd like to talk about any other parts of our proposal today, rather more technical, about our expertise and such, that would make reason why you should proceed with this contract and allow us to get to work with you.
Commissioners?
Madam
Commis-
Chair,
Commissioner Urban?
thank you.
Virtual.
I have had a chance to review your submission, and I'll have to say I'm very impressed with your background and experience and qualifications as a team. And my preliminary impression is that you're eminently qualified to assist us. I just caution my fellow commissioners that I think the threshold issue, after you were the only candidate that responded to the request for proposals. The issue before us today is, are you qualified to serve in that capacity? We are dealing with a brand new statute. I don't think it's fair for anyone to ask us to try to jump into the legal implications of how that statute is to be interpreted at this point. We're simply, the threshold issue is, are you qualified to serve? And then if so, if we find that you're qualified, we'll proceed to contract negotiations for your professional services. And we can deal with all these legal issues at a later time, but I don't think it's fair to force you to address them now. And perhaps Duke would like to be heard after they file their petition on some of these issues, but it's premature to litigate those legal issues at this time. But I want to thank you all for appearing and providing us with your background, qualifications, and expertise today, and look forward to hopefully having an opportunity to work with you in this docket. Thank you.
Thank you, Commissioner Urban, for saying more concisely what I was trying to say.
Thank you, Commissioner Urban. Commissioner Carolee Williams?
Thank you, Madam Chair. Thank you for being here. Thank you for your interest in South Carolina. Thank you for not only thoroughly responding in writing to our request for proposal, but really putting together this PowerPoint that packages it really well, what your strengths are. So I appreciate the effort that went into that. I have a basic question and then a more detailed question. I'm curious, why Sabre? Not in the, why should we pick you, but what does Sabre Partners mean? Where'd you get the Sabre word from?
Okay. As I said, I'm a recovering investment banker. I started 40 years ago as an associate in investment banking in the 1980s. And if you recall, in the 1980s and 90s in Wall Street, acronyms were very important as to describing securities. There were tigers and strips, and that in the market there was a thing called Dutch auction rate securities, and Salomon Brothers had a acronym called DARTS, D-A-R-T-S, Dutch Auction Rate Transferable Securities, and it was really good macho term. And we came up, and they were a market leader in this. And I was at Smith Barney at the time when we were trying to challenge them, and we came up with an alternative product that allowed more flexibility in terms of the pricing of these securities, and we called it share-adjusted broker remarketed equity securities, SABRES. And their tombstone had a little dart in lucite, and our tombstone had a little saber coming out of the lucite. So it was a marketing term. So once we decided to leave investment banking after 17 years and form a company, we were trying to come up with what would be a name. So given that that was a highly successful product, it was used by Exxon Corporation. The Exxon Corporation chose Sabre, myself and Smith Barney over Salomon Brothers, Lehman Brothers, all the big firms at the time. And since it was very important to my career, I thought I'd name the firm after that. Unfortunately, SABRE is owned by the reservation system, the Sabre reservation. So we had to go with the English spelling Saber. So that's how we got it.
Thank you.
Just a little.
Longer story than I
All
thought
right,
I'd get.
but there's a little here.
My other question that's more substantive has to do with page 11 of your PowerPoint. And it's the image that's entitled Ratepayer Backed Bonds, Popular Tool with Explosive New Growth.
Yes.
And I'm just seeking to understand more of what's happening in this slide than in general. What, like, from 2020 to 2021, there's some modest growth in the use of securitization. 2021 to 2022, dramatic change. What's going on? Why the...
Two things. One, weatherization Uri event. So Texas, Oklahoma, and had Texas, Oklahoma, what other state? Primarily Texas and Oklahoma authorized billions of dollars for Hurricane Uri costs. Then we had extreme storm damage from previous hurricanes in Louisiana that came out with a $3 billion transaction. Mm-hmm. But the biggest part was Pacific Gas and Electric Company and the wildfires that occurred in 2018 through 2019, where they were able to get $7.5 billion to help pay for their wildfire victims' claims. And then the legislature authorized additional uses of securitization for wildfire mitigation expenses to prevent wildfires in California. So now additional $5 billion was allowed out of California, in addition to that massive $7.5 billion for that one, for Pacific Gas and Electric. So you have, for not to use a pun, a perfect storm of both hurricane damage, climate-related weatherization event, and wildfire, and everyone having a sort of approach of securitization to the rescue. So securitization would be good, but as you can see, also in that chart and the following, if you just dump all this supply in the market without good supervision and everything, you're going to start paying higher and higher rates associated with that. That shouldn't have to be, because these are the most pristine, safest bonds that could have in terms of its rating. These bonds have never been put on a downgrade list or even downgraded. When Pacific Gas and Electric went into bankruptcy, and I think Northwest Utilities went into bankruptcy, they had subsidiaries with securitization. Nothing happened to the bonds. So these are the safest corporate bonds available. But what you've seen in the last few years is applying it to these extraordinary events that are happening more and causing more damage, and the use of the ability here through this structure with the special government guarantee of regulatory authority with this true-up and this charge on an essential commodity to be used to help mitigate rate impacts and save versus the weighted average cost of capital. So that's what's going on, sort of, that has this explosive growth, and we think it's going to continue on because there are going to be more of these events. For example, we were just talking with people in Florida, Hurricane Ian has caused, and there's likely to be more issuances in Florida to recover those damages.
Thank you very much. I heard you say that in your in the presentation, but the depth of that answer helped me to understand what you said the first time, as opposed to, when I saw the image, it had securitization as a tool gone in and out of favor. And what I hear you saying now, it has more to do with the impact in various states and the amount of use of the tool. Is that fair?
Yes, and I think the concern that we have, it's great to see this tool being used more. We've done transactions from 2000 to, through this year. We're working in Indiana, helping the Consumer Council there. But the notion that it's just sort of like free money or it's automatically saved and we don't have to, we can put it on autopilot, is something we caution against, because you will get what we call a savings trap. And the savings trap is this: you've got the weighted average cost of capital very high for utilities, usually 7, 8% or more. And then you look at the bond rates, and even with inflation, we're at 3, 4, 5%. And we say, oh, well, the difference between the weighted average cost of capital and the bond rate, we're saving money. And you'll always save money when you just do debt and equity, the cost of debt and equity and taxes and everything else that is associated with the weighted average cost versus the pure bond rate. But in that pure bond rate, there's a lot of what Wall Street would call juice, meaning a lot in terms of yield that could be done, a lot of savings. So if you want to maximize, if you just want to get savings and you don't really care about maximizing savings, we can do these transactions very quickly with very little expense. They will sell. But if you're trying to protect the ratepayer and get the maximum amount of savings, because in this transaction, unlike the weighted average cost of capital, you have no further review once you make those bonds or so. You cannot do anything other than increase the charge or decrease the charge relative to electricity sales and demand. So you're going to forego all future regulatory review. And the weighted average cost of capital, you can come back and you can, for prudency, you can make changes on an ongoing basis. Here you got one chance to get it right. And I think that's why we like the legislation asking for a certification and asking for an independent advisory. If you see from our publications and our speeches and from our works in other jurisdictions, this is exactly what we had promoted as best practices, because they produced better results for the ratepayer, and sometimes by tens of millions of dollars, or even more. So it's important not just to say, let's just do securitization. It's a work that has to be done to get the best transaction for the ratepayer and to get the utility the money as quickly as possible, but not sacrificing the ratepayer. Just saying, well, what's an extra couple of cents on their bill? They're not really gonna, nobody will notice. But when it adds up to tens of millions of dollars, I think we notice, and I think you notice. And so that I think that's what you want us to do, is to make sure that the process is competitive, that it comes out with a great outcome. I think, if I might just say, there was the analogy that somebody tried to say, if you and your homeowner, you own a home, you have the same FICO score as your neighbor, you have same houses, you both have a mortgage at, let's say, 8%, and you go for a refinancing. And you get your mortgage refinanced at 6%, and you're feeling great. Then you find out that your neighbor got 5.5%. Mm-hmm. You go back to the banker and you say, hey, I refinanced a mortgage and you get me 6%. And then I saw my neighbor who's got same income, same FICO, he's got 5.5%. How come the difference? And the banker will say, well, you didn't ask. I offered him 6%. He sort of said he didn't really like it and he might go someplace else. So I lowered it to 5.5%. He says, but why are you complaining? You're saving money. It was 8%, now it's 6%. So he's right. as well as you're right in terms of saying, wait a minute, why should I pay more than this other person? So our job is to make that market efficient, to make it so that there isn't any money left on the table, so that everyone will come to a meeting like the Florida meeting in June and say, this is a great transaction, we all work together, and let's move forward.
Thank you very much. Appreciate it.
Thank you.
Thank you, Commissioner Williams. Commissioners, any further questions?
Madam Chair.
Commissioner Urban?
And just to follow up on those last comments that you had, under the law and the way that securitization works, the commission will have no further review once the bonds are issued. That's correct?
They have no further review once the bonds are issued. Prior to the bonds being issued, you can make any changes to the financing order.
Right. And that means we would have no oversight authority, no ability to go back and review any item of the transaction. It's final.
That's correct.
And by the same token, the ratepayers would not have no recourse, would they? They'd be stuck with it on their bill for however long the amortization period is there. They'll have to pay that bill in perpetuity until it's paid in full, because they'll have no review, will they?
That's correct.
Thank you very much.
The only review they have, or the commission has, is for mathematical accuracy, to make sure that there are no arithmetic errors.
Right. But as far as reasonable and prudent expenses and that kind of thing, that's over. It's
yes, that's handled up front, and then the process, and then the bond issue. Once those bonds are issued, it's done. And that's one of the reasons with that meeting in June was to determine whether the commission should issue a stop order on the transaction, meaning that things were proceeding along, and there was a process that was in place that was meant to balance all the interests and allow the negotiation. There was a letter requested by the commission from the advisor to the commission, which was ourselves, to say whether it achieved the statutory objective and the terms of the financing order. We asked and received also very strong letters from the underwriters and from the company. I think we didn't ask as strong a letter from the company as from the underwriters, because those were on the other side and we were giving an independent. And then we present that to the commission, and the commission can say, the transaction proceeded as they said there, or they could say, no, we think that this is, well, we're going to stop. You go back and redo the transaction. It's hard to stop a transaction, so it's important to try to have the process get to the point where everybody will agree. But that's where there's some tension and negotiations and going back and forth between the utility, the underwriters who want to just say, our customers are ready, here's the money, door number one. Here's the cash, take the cash, take the cash. And where you might say, maybe you need to talk to some more people. Maybe we're worried a little bit about what the Fed is doing. We have Alan Blinder, the former vice chairman of the Federal Reserve, as our chairman of our advisory board. He came in the Florida transaction when Florida proposed hedging the $1.2 billion transaction 9 months before the transaction was supposed to take place, and gave a briefing about we didn't think that rates were going to rise dramatically over the next 9 months, that the hedge would have been too expensive the commission decided, the utility never formally submitted the hedging proposal based on our feedback. And had we hedged, we would have lost $80 million at that point. But those are the kinds of questions you're going to deal with and address, and we provide the information to you to make those decisions.
Thank you, sir. No further questions.
Thank you, Commissioner Urban. Commissioners, anything further?
Can I ask a question? Isn't the deadline in terms of making your decision December 1 or 3?
Yes, well, yes, sir, that's what I was gonna go over with you. If you will recall, there was a directive issued in October. Are y'all familiar, have you been on the docket management system, the commission, with regard to this docket? Everything that's filed in this docket is on the
We're
web
familiar
page.
with that. I don't think we're not a registered recipient of any information because we were simply a vendor responding to your proposal.
Okay, the final, this should have, I think this would have been put out by the, procurement group, but, we asked that a final conflicts check letter, be filed with the commission by noon on Monday, November 28th, and then this will be the decision of whether or not to hire you or not, will be at next Thursday's business meeting, December 1st. We'll take a vote on that. So if you could do, and we can get you a copy of this directive order before you leave today.
I think we were aware of it. That's why I thought that
Yes,
December
sir. If you knew the December 1st date, I
and
think
the
you've
conflicts,
seen
we
this.
have we also offered in an RFP to go further than the conflicts that you asked for, so that we would, after the transaction, agree not to work for Duke Energy if ever they asked to hire us for at least a year or more, and not to trade or underwrite any securities related to this transaction for at least 12 months as well. So we think conflicts and independence is very important, and we would like to go further than that, than with the simple that we don't currently have any conflicts. We have seen people who don't have current conflicts, but then they think about future business, right? You know, they finish that and then, oh, you did such a good job on that. Come work with us. Well, we're going to say we're going to keep us out of that, because we're not going to accept any of that work, and we're not going to be involved in any of that, because we think integrity, as I said, was one of the core values of our firm, is to be on our client's side and never on the other side.
Thank you. And you might want to be aware of the docket management system, because there's also feedback from interested parties, which could include Duke Energy Progress and Office of Regulatory Staff. I don't know if we have any interveners in this docket. We've opened the docket. Hasn't gone. But they can provide feedback to this public interview by Monday as well. So you may want to be aware of that if you want to look at that. So if there's nothing further from the commissioners.
Is there going to be a review like Rotten Tomatoes? Or are we going to get a score?
I don't know. It just
Mr.
depends.
Fitzgerald's presentation was only 65% fresh.
It would be, it'd be like.
We've heard it before. It's so old.
We think that there's a conflict, or we think that they're not qualified, or have whatever party may say. Commissioner Caston, did you have something further?
Madam Chair, no, I was just going to simply tell them to go to South Carolina Public Service Commission website, and it's DMS.
It's DMS on the homepage. It stands for Docket Management System. You plug in the docket number 2022-256-E, and it brings up everything that's filed in there. There's a tab for matters. There's a separate tab for orders. There's a tab for parties, interveners, that kind of thing too. Gentlemen, thank you for being with us. We appreciate your detailed response to the RFP. Appreciate the details that y'all provided in the PowerPoint and the responses to the questions. And we will look for the final conflicts check letter and the answer, just brief responses to those questions in the DEP letter by noon on Monday. That's the 28th. So thank you very much. Anything further from y'all?
No, I think you told, if the timetable is the same,
and then this will be on our agenda for the business meeting that we hold on December 1st.
Would it be helpful for us to be there if you need?
You can watch it on live stream.
I mean,
I would hate for you to incur the cost of coming down. We don't really take questions
Oh, I was just saying if you had additional questions, if you were to be voting.
If we do, I think we would send those through Mr.
Oh,
Hall,
okay.
through Matthew Hall.
Okay.
So, thank you.
Thank you.
Do appreciate your attendance and your attention to the RFP, and thank you for responding. With that, our next regularly scheduled commission business meeting is scheduled now for Thursday, December 1st at 2 p.m. And with that, we will adjourn this meeting. I wish everybody safe travels today, and everybody wishing you a happy Thanksgiving.
Thank you.
Thank you very much.